Good morning and welcome to PV Legal's daily newsletter. Can the ruling party appoint the very body that referees its own elections? That is the question the Supreme Court of India is now being asked to answer. And the answer will determine whether the Election Commission of India is truly independent or structurally captive to the executive that appoints it. The case is Dr. Jaya versus Union of India, WPC number 14 of 2024, currently being heard before a bench of Justice Dipankar Datta and Justice Satish Chandra Sharma. It challenges the Chief Election Commissioner and other election commissioners' appointment, conditions of service and term of office Act 2023. The law parliament enacted to fill the vacuum that the Supreme Court identified in Anup Baranwal versus Union of India, decided on March 2, 2023. Here is the background. For 73 years after the Constitution came into force, Parliament never enacted a law governing the appointment of the Chief Election Commissioner and election commissioners, even though Article 324(2) explicitly anticipated such legislation. Every government simply exercised unfettered discretion. In March 2023, a 5-judge constitution bench stepped in. Using its power under Article 142, it directed that until Parliament legislated, appointments would be made by a 3-member committee. The Prime Minister, the Leader of the Opposition, and the Chief Justice of India. Parliament responded with the CEC Act of 2023. It created a selection panel of 3, but replaced the Chief Justice of India with a Union Cabinet Minister nominated by the Prime Minister. The result, 2 members out of 3 represent the executive. The Leader of the Opposition can be, and will routinely be, outvoted. The petitioners are pressing 3 central constitutional arguments. First, that an independent election commission is part of the basic structure of the Constitution, and Parliament cannot legislate away that independence even through an otherwise valid statute. Second, that executive dominance of the appointment process violates the fundamental rights of voters under Articles 14 and 19 because the legitimacy of elections rests on the impartiality of the institution that conducts them. Third, that the ruling party is the principal contestant in elections and cannot constitutionally be allowed to control the appointment of the referee. The court has not yet ruled. The matter is ongoing, but at the last hearing, Justice Dipankar Datta made a pointed observation. He said that the Anup Baranwal judgment was was only to fill the vacuum till the law is made, and that it contained no direction that Parliament must frame the law in any particular manner. That observation cuts both ways. It may limit the petitioners' reliance on the 5-judge bench, but the petitioners have been clear. Their challenge is grounded not in the judgment, but in the Constitution itself. Senior advocates Vijay Hansaria and Prashant Bhushan both argue that even without Anup Baranwal, the same constitutional infirmities would exist. The court has also noted that specific pleadings on the invalidity of Sections 7 and 8 of the Act need strengthening, signaling a rigorous approach to the merits. What does this mean for practitioners and citizens watching this case? The outcome will settle a question that goes to the heart of Indian democracy. Not just who appoints election commissioners, but what constitutional flow Parliament must observe when in doubt. If the court holds that basic structure constrains ordinary legislation on institutional independence, the implications extend well beyond the election commission. Watch this space carefully. For the full legal analysis, subscribe to PV Legal's daily newsletter. This is your host, signing off for PV Legal's daily newsletter. Stay informed, stay vigilant.